Hello students, in our previous video we have discussed various case studies relating to the offer and acceptance. In this video we will be discussing on the problems or case studies relating to the capacity of the contract, lawful object and consideration, and also performance and discharge of contract. So let us start analyzing one by one the questions relating to the Contract Act. First being Ritik, aged 17 years, who has purchased a mobile phone for 25,000 rupees for his online classes from mobile sales centers on credit basis. On due date, he did not make the payment of mobile. Mobile center sued Ritik and his parents for the price of mobile. Ritik has 15,000 rupees as his cash balance, but his father has enough money to pay the price. Examine the given situation and answer who will be liable to pay the price of mobile. Students, this question is arising out of section 11, the agreements entered by the minor. The position of the agreements with respect to the minor is void ab initio because they are incompetent to enter into contract. However, the law also allows minor to become a party to the contract as a beneficiary or a promisee. Minor can become a beneficiary or promisee, but he cannot become a promiser. So hence in this case, the supply of mobile phone, if it constitutes necessaries, then minor is liable for the supply of necessary. But however, minor is not personally liable, minor's estate is liable. So the answer for this question is that Ritik's assets, that is to the extent of 15,000, since he is having cash, that is liable, and the balance 10,000, it is not recoverable. So Ritik is liable only to the extent of 15,000 because he is having asset of 15,000. Moving on to the next question. So discuss the rights with the promiser in following cases under Indian Contract Act 1872. So first being the Sunil promised to bring back Anil to life again. Students, this is a case of possibility of performance. So in this case, the possibility of performance is not possible, isn't it? The possibility is not there because you cannot bring back the life to a dead man. So in such section 56 talks about the initial impossibility itself. So when the impossible acts or an agreements to do an impossible acts will be regarded as void ab initio. So this is void ab initio. And second one, Suman agreed to sell 100 kgs of apples to Raman. The loaded truck left for delivery on 15th March, but due to riots in between, reached Raman on 19th March, due to which the apples were rotten. So, students, this is the situation of supervening or subsequent impossibility. So, subsequent impossibility makes the agreement again void. So, this is not possible due to the destruction of the subject matter. So at the time of entering into contract, the arrangement was very much valid, but because of the subsequent event, the destruction of the subject matter, this contract becomes void. Third being, an artist performed to paint on the fixed date for a fixed amount of remuneration, but met with an accident and lost his both hands. See, this is a personal contracts, meaning the contract which requires personal skills and creativity. So this cannot be assigned to anybody else. It has to be performed by the promiser only. But however, since he is unable to perform, it has become an impossible to perform because there is a accident happened and he has lost both of his hands. So such contract, due to the personal in nature, it cannot be performed, and event resulting in impossible to perform, so leading to void. And the last situation is Abhishek entered into contract of import of toys from China, but due to disturbance in the relation of the countries, the imports from China were banned. So this is basically at the time of entering into contract, it was very much valid, but in subsequently, because of the prohibition or restriction, if it continued, it becomes illegal. So, in such a scenario, such contract is discharged without performance because of subsequent illegality in the nature of the contract. So, students, to remind you, I'm just explaining the legal provisions. If you need a detailed model answers for each question, please email us at lathoreacademy@gmail.com, or just ping in this particular video your email ID. We will be sharing the model answers. So next question is a simple plain question which requires only an explanation to the question. This is not a case study. So set out the conditions to be fulfilled to make the agreements valid without consideration. Students, every contract requires consideration. The general rule is that no consideration, no contract. But however, there are certain exceptions carved out in the Contract Act, where even though there is no consideration, it is considered as uh, valid contract. So 25 subsection 25 subsection 2 talks about this natural love and affection. When the contract is entered between the parties out of natural love and affection, the agreement is valid even though there is no consideration. But however, the conditions to be mentioned is that it has to be in writing, it has to be registered under the law, and it is made on account of love and affection, and the party standing between the contract must be in near relation to the each other. So all these four conditions have to be satisfied. So, and one more point is that mere nearness in the relation itself does not necessarily imply natural love and affection. There might be relatives, they might be close relatives, but if there is not natural love and affection while creating a contract, this particular exception will not apply. And another question is that promise to pay time barred debts. So the debt which has become time barred, here you have to remember that law of limitation act applies to the debts. If it is not recovered within 3 years, the debt will become time barred, and it is, you cannot recover it. Even the court also cannot enforce in such a situation. With a restricted explanation regarding the Indian Contract Act, we are discussing this. So what happens when the debt has become time barred? You cannot enforce it for the repayment. But however, when the debtor agrees, when the promisor agrees or promises to pay the time barred debt, it is valid even though there is no consideration, if and only if it has to be made in writing, it has to be signed by the debtor or his agent also, authorized agent, and the agreement, the writing, and the amount which is certainly certain amount signed by the debtor has to be the debt which cannot be enforceable under because of the law of limitation. So the debt which could not be enforced by the creditor because of the law of limitation. So the three conditions have to be satisfied in order to classify under this exception. So next question is that quantum merit. So the discuss the four situations where the quantum merit arises. So the quantum merit basically it means as much as earned. So what does it mean? As much as earned or as much as deserved. So for example, in case of void agreements, what happens? The promisor has done some acts out of the contract, and subsequently it turns into a void contract, void agreements. So in such a case, you are supposed to compensate to the extent of work done by the other party. And another second situation is that when you are preventing the other party to perform, he has performed partly, but you are preventing him to not to perform. For example, if you have hired a contractor, construction contractor, to construct a building, he has done first floor, but you have stopped him from constructing the second floor. It means you are preventing him to construct, because of which he is unable to perform his job. But however, since he has done first floor construction, you have to pay to that extent. So the second situation could be that when you are preventing the other party from completing the contract, it is your responsibility, it is your obligation to pay for the portion what the other person has completed. And the third situation is when someone has done not with an intention to do gratuitously. Gratuitously is something which means done with an intention to get some remuneration. So gratuitously means without any expectation. Not non-gratuitous means not done with an intention to do free of cost. Matlab, there is some consideration is expected. For example, when a plumber in an emergency situation, he fixes or repairs your leakage pipe. So even though it was not agreed beforehand, it is your duty or it is your obligation to pay, because he isn't doing it for free of cost, right? So reasonable compensation is expected by him. So the quantum merit arises in this situation. And the another situation is that when the contract is divisible contracts where part of work is performed. So for example, when you have hired someone to cater for your wedding or any birthday event, when you have hired a caterer who is have to do who has been entrusted with work such as food, decoration, and staff handling, all these responsibilities when you have entrusted to him, and when they have completed the food part services perfectly, but they have failed in decoration part, but you have to pay him at least to the extent of food, right? So when the food services they have fulfilled, it is your duty to pay fairly for the food portion which was successfully delivered. So quantum merit arises in this situation where the divisible contracts done, but it is some part is done properly, some parts are done not properly. So these are the four situations wherein you can explain in the exams. Next question is based on the ABC jointly promised to pay 60,000 to D. D demands the entire amount from A. So ABC, they have jointly promised to pay D. Basically, D is a lender, ABC are the borrowers jointly. So D demands the entire amount from A. Can D recover the entire amount 60,000 from A alone? So what are the liabilities of the joint promisors under the Indian Contract Act 1872 in the absence of an express agreement to the contrary? Students, this particular problem is case study is coming from the provisions of section 43 when two or more persons make a joint promises. This is basically the question of joint promises. Joint promise. So the liability of the joint promisors is joint and several. So what does this mean? It means the joint promisors A, B, C are liable jointly and severally. What does this mean? For example, in this case, there are two questions: whether can D recover from A first part, and the second part, what is the liability of the other joint promisors? So coming to this particular scenario, whether D recover from A alone, yes, the provisions of law allows Mr. D to demand full performance from any person. Here in this case, D can demand full performance from A alone, individually. He can choose any promiser to that extent. So for the first question, the answer is affirmative, that yes, D can recover the entire amount from A. But the law does not stop A from recovering this from B and C. So what does it mean? It means A will get, D has every right to get money from A entirely. In addition to this, law also gives right to A that he can claim from B and C for the rest of the amount. So after paying D, A can demand contribution from B and C. So in this case, so assumingly there is a equal responsibility 60,000. All three are liable for 20,000. Then when A has paid 60,000 entirely to D, then A can recover 20,000 each from B and C in this case. So B and C are liable for A 20,000 each. Suppose if B or C, either of the party, if any of the party become insolvent, for example, B become insolvent now, then A, and suppose B becomes insolvent, now A and C have to bear the loss proportionately now. So in such a case, law also gives responsibility to C to share the loss in the case of any joint promisor turns into insolvency. So next question, A agrees to marry B if he inherits property from his uncle. So the moment is if is coming here, this means conditional, isn't it? Conditional. So section 31 talks about the contingent contract. It's a contract to do or not do something if some event collateral to such event does or does not happen. So this is conditional or contingent contract. So if he inherits property, he is going to marry. A does not inherit property, B sues for breach. See, here the enforcement of the marriage contract is dependent on the inheritance of the property. The agreement is no doubt valid. The agreement is no doubt valid. But the enforcement rules, section 32 talks that when the contingent contract depends on uncertain future events, can only be enforced if the event happens. Because in this question, if the event happens, event means here the inheritance of the property. If the event happens, only it is enforceable, otherwise it is not. So the answer for this question is the agreement valid? Yes, agreement is very much valid, but however B cannot sue. B is unable to get any reward or be any favorable order from the court, considering there is no breach occurred since A's obligation was conditional or contingent upon the inheritance of the property. Since he could not inherit, he is not able to marry. Moving on to the next question, a rich businessman gifts 50,000 rupees to a minor, Meera, through a valid deed. Later, the businessman demands the money back, claiming Meera cannot be the party to the contract. This particular question is arising out of the capacity to the contract. So generally what happens, any contract entered with minor is void ab initio, but however nothing stops to enter contract by the minors if it is beneficial to them. If it is beneficial to them, it is valid. So in this case, the gift is it is beneficial to the minor and it does not create any obligation on the minor part, isn't it? So minor is not liable at all and he is not a promiser. He can receive gifts, and also a completed gift is also a valid arrangement, so valid consideration. And it is, even though there is no consideration to the other party, minor Meera is receiving consideration, fine, but the other party, rich businessman, is not receiving any benefit or any consideration, it is also fine, because no consideration, no contract, exceptional rule is there, that is completed gift. So the conclusion here is that this was a gift, and minus contractual capacity is irrelevant in this case, considering he is only a beneficiary. So in this case, businessman cannot recover the money back as it is a completed gift, and minor is in a beneficiary position. Next segment, wherein a 3-mark segment, Mr. Karthik promised to deliver 50 bags of rice to Ravi. No time or place of delivery is mentioned in the contract. As according to the Indian contract 1872, what are the rules regarding the time and place for the performance of the promise? What happens in the case of absence of time and place? If no time, see, generally what happens in the contract, if time is mentioned, you have to deliver within the time limit. Section 46 talks about that. If it is not mentioned any time, then you have to perform within the reasonable time. What is reasonable? It depends on the circumstances, situation, which is varying, isn't it? So when the time is not mentioned, when the time is mentioned, you have to perform within the time limit. If no time is specified, you have to perform within the reasonable time, depending upon the circumstances of each case. Whereas with respect to the place of delivery, section 49 talks about the contract must be performed at the place where it is specified. If no place is specified, then performance can be at a reasonable place. But however, there is also a condition which is put in section 49, is that it is the duty of the promiser. It is the duty of the promiser, in this case Karthik, it is the duty of the promiser to apply to the promisee to appoint a specific place. It is the duty of the promiser to apply to appoint a specific place for the performance, and it has to be performed in the such place. So this is the rules regarding the time and place. So he must ask, in this case, the time limit, even though it is not mentioned, it has to be mentioned within the time limit. And place, he must ask Ravi, the Karthik must ask Ravi to specify a reasonable place for the delivery, and the delivery should be taken place at that designated location. Next, ABC Limited contracted to deliver 100 bags of cement to XYZ company's warehouse by 30th April. On 29th April, the truck arrived at XYZ company warehouse with 100 bags of cement during business hours. So it was to be delivered within 30th. It is about to deliver on 29th. It is arrived at a warehouse, and whatever the contracted quantity, it is being delivered with 100 correct bags, and during business hours, there is a correct business hours within time limit they have arrived. However, the watchman at the gate refused to allow the truck to enter, stating that warehouse manager was unable to take delivery. ABC Limited left with the cement. So can ABC Limited consider to have performed their part of the contract? Discuss the legal obligations. See, student, this question is arising out of the attempted performance. So this is basically an performance chapter, which is, we call it as tender or attempted performance. So here section 38 is applicable in this case. Section 38 talks about when a promiser has made an offer of performance to the promisee and the offer has not been accepted, the promiser is not responsible for non-performance, nor does he loses the right under the contract. So in this case, the ABC Limited, who is a promiser, has made a proper tender because of the points what we have. What was contracted is to deliver 100 bags by 30th April to the warehouse. So all the conditions are fulfilled, because the tender, in order to become valid, it has to meet certain conditions. All the conditions have been fulfilled with respect to the time, place, the manner, and as well as the quantity. So when the valid tender has done and the promisee has refused to accept it, even the promisee's authorized representative, in this case the watchman also is a authorized representative of the promisee, has refused to accept it, which has led to the legal consequences under section 38. So in such a case, ABC Limited is not responsible for non-performance and contract obligations are discharged, and he retains the ABC Limited retains the rights under the contract and can claim damages and also not liable for any consequences of non-delivery. So these are the consequences or implications and of this particular case study. Madhav owns a factory that operates without proper safety measures and pollution control systems as required by law. He enters into an agreement with Jagat, promising to pay him 3 lakh rupees per month for helping him evade by giving advance warning of inspections and helping to temporarily set up fake security measures during inspections. Later, Jagat demands payment as per the agreement, but Madhav refuses. Jagat files a suit for recovery of amount. Advise Madhav with reference to the relevant provisions of the Indian Contract Act. Students, this particular question is arising out of the legality of object and consideration. So, when the object or the consideration is unlawful, this is void, isn't it? So, in this case, it is defeating the provisions of law. The going by the facts of the case, the agreement is specifically aiming to defeat the provisions of environmental laws here, isn't it? So which is safety regulations of the factories, which clearly is the object is and the purpose is to defeat the law. Hence it is of unlawful nature, and section 24 talks about this, that when the considerations are unlawful, the agreement is void. So this you have to explain the provisions relating to the 23 as well as 24, which the contract states that if the consideration is unlawful when it is forbidden by law, or when it is of such nature that if it is permitted it would defeat the provisions of law, or if it is fraudulent, or if it involves or implies injury to the person or property of the other. So all these reasons you can mention in your answers. Next, A promises to gift his old car to his friend B without any exchange. B accepts the promise. Later, A refuses to give the car. So can B enforce this agreement in the court of law? So generally what happens when there is no consideration, no contract, isn't it? So no consideration, no contract. It is merely a promise to gift. Please remember this. So what happens when see, in certain situations where there is no consideration, there is no contract. Very general rule. But however, when there is a completed gift scenario, even though there is no consideration, it is regarded as valid contract. But however, in this case it is merely a promise to gift, it is not a completed gift. So hence in this case it is not enforceable, because simply promising to gift is having no legal sanctity, or there is no legal consideration moving from the other party. This will not be covered under the exceptional situations for no consideration, no contract. So this is not enforceable at all. So this you have to explain consideration definition as well as section 25, where the agreements without consideration are void. However, in the exceptional case of completed gift, it is valid, but in this case it is not a completed gift. This contract is this arrangement is not enforceable at all in the eyes of law. So there are couple of other questions also which we will be discussing in our next part. So if you like this video, please do not forget to like and subscribe, so that we will be constantly supporting you with these kind of relevant case studies. And please do watch out our upcoming videos on these interesting case studies, wherein we have discussed the solutions and how to answer these case studies in order to secure good marks in the examination.